Hi, today we will be talking about Section 230, liability in big tech. My name is Becca Lormer.
I'm Katie Harris.
I'm Katrina Lynch.
I'm Nick Verticano.
And I'm Addison Vasconcelos.
Okay, so starting out with what is Section 230? Section 230 is part of the Communication Decency Act to protect both users and computer service providers. It specifically states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This pretty much means that social media websites are not liable for users' posts or removing them if they choose to do so. This law has implemented what is called a sword and a shield. The sword represents the removal of any content the provider feels unfit for their site, while the shield prevents certain content from being even posted on the site. This regulation also prevents users from being liable for comments or responses on their posts. Now getting to the background information. Section 230 was created in 1996 by Ron Wyden, an Oregon senator, and Chris Cox, a California House representative, to make sure that large tech companies at the time were not liable for their users' actions or choosing to moderate it, but it also aimed to protect free expression. It was created as a response to a couple of lawsuits against internet service providers because there was a dispute as to if these ISPs should be treated as publishers or distributors of content in terms of liability. Obviously, the verdict was that they were not liable for content published by others on their site. I now want to summarize some of the main points of Section 230. First, it contains two main protectors. The first one is protection from liability when they choose to not take action to remove third-party content, and the other one protects them from liability if they do choose to take action. Next, Section 230 does not entirely protect providers. The violation of other laws, such as criminal, copyright, or sex trafficking laws, are still considered illegal and punishable if violated. Moving on, Section 230 was created to propel the growth of the internet, especially back when it began, which has obviously been successful as we see the internet being a crucial part of our lives today. Section 230 has also allowed for a multitude of different business models to gain success on the internet, and some even say that Section 230 is partially responsible for the creation of our modern internet. Finally, if Section 230 did not exist and providers were liable for everything that happens on their sites, there would be so many more expenses and legal issues that would arise, which would halt innovation online and also have bad effects on our United States economy.
Why does Section 230 matter? Section 230 is a pretty important law, which is also one of the hottest topics in the internet and telecommunication regulation. The provision did not attract too much attention when it was first signed, but this changed monumentally in the recent years. Section 230 is controversial, but it matters tremendously because of the effects it has on corporations, specifically within big tech. There are countless amounts of cases that have been decided by Section 230, and a majority of them spark debate on many different issues. Big tech has the power to the extreme of even being able to silence the President of the United States. Section 230 gives no liability to any platforms for their users' posts and actions on their sites. As a result, many corporations have been able to be careless for censorship, and some go as far as abusing it. I want to point out a couple of cases where Section 230 was or was not applied. In Barrett versus Rosenthal, website operators and medical doctors Stephen Barrett and Terry Polivoy brought defamation action against Eleanor Rosenthal, who is the director of the Humanities Foundation for Women and host of an online discussion group. Rosenthal did not censor any posts, despite knowing they may have been false. Barrett and Polivoy were being slandered with defamatory messages, which attacked these doctors personally and accused them of dishonesty. This was a pretty big case as different levels of the court were in disagreement over this issue. First, the trial courts dismissed the defamation claim and thought Section 230 applied to Rosenthal. Shortly after, the California Court of Appeals actually went against lower courts because Section 230 supposedly only applied to publishers, not distributors of defamatory information. They ruled that Rosenthal did not fall under the publisher category, but instead distributor. However, on appeal, the California Supreme Court revered and ruled in favor of Rosenthal as they interpreted Section 230 differently and believe it applied to both publishers and distributors. As you can see, the courts even had disagreement on the provision, and we're not really sure how much ground Section 230 really covered. On another note, I will present a case where the Communication Decency Act was not applied. In Anthony versus Yahoo, Anthony attempted to sue Yahoo for creating false profiles on their dating websites and services in order to keep customers hooked to the website. Yahoo claimed that Section 230 protected themselves from this case, but the courts actually disagreed. Since they created, not failed to remove the profiles, they were indeed held liable for their actions here. Their dating services claimed to be fully genuine, and Anthony was able to bring up multiple claims that showed their dishonesty. Both these cases prove that Section 230 is important because there may be a change to the provision in the near future.
All right. Well, first we can give a little bit of context regarding Section 230 and its early ties to big business. Section 230 in relation to big business has had a major influence on internet platforms and their incredible success. Section 230 was initially passed to promote the growth and development of the internet by creating a broad range of protection to allow online free speech to thrive. Back in 1996, when the section was first passed, many of the large platforms that we know so well today, such as Facebook, Twitter, and Google, were not even startups. These three platforms greatly benefited as they heavily rely on the use of third-party content, which Section 230 aids with protection from litigation. Some would even say gives them a sort of immunity. Section 230 provides these platforms with an unprecedented amount of freedom to moderate their platform at their own discretion, which in 1996, when the act was passed, made sense given the youth and inexperience of the internet. Now, as these businesses have grown larger, with Facebook having almost 3 billion users and Twitter having around 400 million, these rules are less applicable and make even less sense. Section 230 is no longer working properly given this current state of the internet, as many of these massive platforms now boast too much influence on the world to have this immunity and should be held more accountable. These platforms are now benefiting greatly from their immunity by allowing misinformation and fake news to garner more views and activity on their website. Thus, big business is greatly increasing their profitability by allowing misinformation on their site, which creates a major conflict of interest between the company's profitability and their duty to publish information to properly inform their users. One example of the benefit these platforms receive from misinformation is a study that found during the 2020 election, misinformation content on Facebook got 6 times the clicks than factual news. The disparity in clicks of the fake news versus factual news is believed to be the company's algorithms fueling the spread and popularity of the misinformation. This shows the obvious incentive for big business to allow or even intentionally design their platform to support the content that will be most popular, thus supporting fake news for monetary gain. In doing this, Facebook is doing nothing legally wrong and is not held liable for its decisions around the moderation of its platform because of the immunity from Section 230. Another example of Section 230's dysfunction is Google and its promotion of fake news and misinformation because of the profitability of doing so. Google allows misinformation to spread by partnering with websites that produce inaccurate or false claims, which not coincidentally get the most clicks and produce the most money. The CFA, a nonprofit organization which aims to promote ethical standards in the global investment industry, recently did a study on Google, finding that the content publishers known for publishing misleading content made up over 68% of Google's revenues from that specific study, which amounted to about $49 million. All in all, it would be fair to say that Section 230 has an overwhelmingly positive effect on big business, which most would argue is to a fault. The businesses are being treated as if they're small, sprouting companies in need of protection from litigation, which the section was originally passed for, but are in actuality some of the largest, most powerful companies in the world. And that leads us to our next section.
Since 1996, when Section 230 was created, there haven't been any real or significant changes. The only noteworthy modification to the bill occurred in 2018, when the Fight Online Sex Trafficking Act was passed with overwhelming support in both chambers of Congress. Former President Trump signed into law the FOSTA Act, which added an exception to the absolute liability shield that Section 230 provides to tech companies. The FOSTA Act makes websites liable if they knowingly assist, support, or facilitate activity violating federal sex trafficking law. The bill changed Section 230 by opening internet companies up to a potential stream of lawsuits over online activity that they were previously legally protected from. Many companies have strong opinions over Section 230 and believe that it needs to be updated. Although we can all agree that some changes need to be made, there's a lot of political controversy surrounding what those changes should be. Republicans want to strip 230 protections to make online companies not moderate users' content, because they believe this gives media companies the power to control politics by allowing their preferred political party to post things and prevent their opposing political party from doing the same. On the other hand, Democrats want to increase the protections to allow companies to fight against misinformation because they believe that unregulated, negative, and violent posts can harm society at large. Since Section 230 was passed into law at the turn of the century, social media companies have had countless technological and societal innovations, making the protections of 230 severely out of date and insufficient for the task of equally protecting the rights of consumers and online business owners. A repeal would likely cause many changes in the short run, including a significant shift in online companies, and increased costs would likely run many startup companies out of business. In the long run, the information available online would not drastically change from what is available today. Moving on to what regulations could protect business owners. Section 230 is very beneficial to business owners of online websites because it completely shields them from harmful information posted by third parties and gives them the power to police and monitor their websites. Section 230 allows online business owners to decide what information gets to stay on their sites and what information gets deleted. And it is up to the judgment of big tech companies to control what information consumers see on a daily basis. Many people have argued that this absolute legal protection and power has reduced the incentives of big internet companies to proactively remove content causing social harm. If this legal protection was taken away, social media platforms would be motivated to more effectively regulate their sites to avoid potential lawsuits, which would benefit businesses who are vulnerable to defamation before changes to Section 230. Although revisions to Section 230 would be intended to change the platforms of big tech companies such as Facebook and Google, it would more harmfully affect the small startup companies. This is a quote by Senator Ron Wyden, who introduced Section 230, explaining why it should be upheld. The biggest tech companies have enough lawyers and lobbyists to survive virtually any regulation Congress can concoct. It's the small startups seeking to displace big tech that would be hammered by the constant threat of lawsuits. Whenever laws are passed to put the government in control of speech, the people who get hurt are the least powerful in society, said Wyden. What Wyden is saying here is that if we pass any kind of regulation that targets online platforms, big tech companies aren't going to change their ways. They will probably just get better at hiding it. But the smaller online platforms will suffer substantially. Instead of passing a law that targets all online tech companies, lawmakers are considering different ways to target big tech companies while still protecting small business owners from the adverse effects. One example of this kind of regulation is the Mind Your Own Business Act proposed by Senator Wyden. The MYOB is a privacy law that includes strong enforcement provisions for tech executives and anti-competitive practice regulations. Wyden's MYOB Act would protect Americans' privacy, allow people to control the sale of their personal data, and give the FTC the power to spur a new market for privacy protecting services. This bill gives the FTC the authority to establish minimum privacy and cybersecurity standards, issue large fines of up to 4% of revenue on the first offense, and 10 to 20-year criminal sentences for senior executives who knowingly lie to the FTC. The FTC could also create a national do not track system that allows people to prevent companies from tracking them, selling or sharing their data, or targeting them with personalized advertisements. Under this bill, companies that want to condition products and services on the sale of consumer data must offer a privacy-friendly version of their product, for which they can charge a reasonable fee. Companies must also give consumers a way to review their personal information a company has collected on them and learn who it has been sold to. To be compliant with the FTC, companies must also hire 175 more staff to regulate and police the market for private data, and companies must examine their impact on accuracy, fairness, bias, discrimination, privacy, and security on consumers' personal data. And moving on to our next topic.
Our next topic is oversight boards. Oversight boards are a system currently put in place by Meta that oversees the control of Facebook and Instagram. The oversight board was originally created to help Facebook answer questions around freedom and expression, what to take down, what to leave up, and why. The board will eventually consist of 40 members ranging from different disciplines. The oversight board appealing process gives people a way to challenge content decisions on Facebook or Instagram. If someone does not think that a piece of content should be on Facebook or Instagram, they first need to report the content to Facebook. Then, if an appeal makes it through, a panel will deliberate the case. When the board selects a case to review, it typically takes up to 90 days to make a decision. Oversight boards were created to add extra regulation beyond Section 230. Although Section 230 states that companies will not be held liable for any content created on their sites, there have been proven to be ethical concerns around this when the company is held liable. This has come into play after Facebook's $5 billion settlement after violating the consumer privacy and data security. Mark Zuckerberg, the CEO of Facebook, then decided that he wanted to create a quasi-judicial review of Facebook to address the ethical concerns of content being posted and data being abused. So far, the board has reviewed 10 decisions, including the one made about banning Donald Trump's account. Decisions made on the oversight boards to remove posts include racism, indecency, or violence. One major decision that the Facebook oversight board was made to ban Mr. President's Trump's account on January 7th after he used social media accounts to spread disinformation that incented a mob of supporters to attack the Capitol a day earlier. These decisions to monitor Facebook helps protect the consumers on the app from harmful content. And although at this point, Section 230 is technically not responsible for any change in the future, there will be amendments and new bills being passed. Now on to recent news for Section 230. And first, we're going to be showing a quick video to explain Oversight Board.
Facebook's Oversight Board on Tuesday announced an expansion of its remit so that users can appeal content left up on the site as well as content taken down. Here are some key facts about how the board works. What does the Oversight Board review? The board, which some have dubbed Facebook Inc.'s Supreme Court, can overturn the company's decisions on whether some individual pieces of content should be displayed on Facebook or its photo sharing platform Instagram. It can also recommend changes to Facebook's content policy based on a case decision or at the company's request, but these are not binding. The board, which only makes rulings on a small slice of Facebook's content decisions, said it aims to pick cases with wider relevance. It said it has received more than 300,000 cases since it opened its doors in October 2020, and it has ruled on fewer than 10. It will not deal with Instagram direct messages, Facebook's messaging platforms WhatsApp and Messenger, its dating service, or its Oculus virtual reality products. How does the board work? The board, which is supported by a staff, decides which cases it reviews. Cases can be referred either by users who have exhausted Facebook's appeals process or by Facebook itself for significant and difficult cases. Each case will be reviewed by a panel of 5 members, with at least one from the same geographic region as the case originated. The panel can ask for subject matter experts to help make its decision, which then must be finalized by the whole board. The board's case decision, which is binding unless it could violate the law, must be made and implemented within 90 days, though Facebook can ask for a 30-day expedited review for exceptional cases, including those with urgent real-world consequences. Users will be notified of the board's ruling on their case, and the board will publicly publish the decision. When the board gives policy recommendations, Facebook has to publish a response within 30 days. Who is on the Oversight Board? The board will eventually have about 40 members. Facebook chose the 4 co-chairs, former U.S. Circuit Judge Michael McConnell and constitutional law expert Jamal Green from the United States, Colombian attorney Catalina Botero Marino, and former Danish Prime Minister Helle Thorning-Schmidt, who selected 16 other members jointly with Facebook. Some picks resulted from the global consultations conducted by Facebook to obtain feedback on the Oversight Board. The members, who are part-time, also include civil rights advocates, academics, journalists, a Nobel Peace Prize laureate, and a former judge of the European Court of Human Rights. One member, Pamela Karlan, recently left to join the Biden administration and is being replaced. The members are paid by a trust that Facebook has created and will serve 3-year terms for a maximum of 9 years. The trustees can remove a member before the end of their term for violating the board's code of conduct, but not for content decisions. If you enjoyed this video, then hit the
Perfect. So I hope that made sense to you guys. Next, we will be moving on to recent news regarding Section 230. So as Nick discussed earlier, Section 230 is constantly in the news and is being spoken about, but why? This is because Section 230 has had huge controversy within the 2 main political parties. After Donald Trump was banned from Facebook and Twitter, the Republican Party declared that Section 230 is going too far and monetizing too much. They thought that Facebook was being too sensitive and taking away one's right to freedom of speech. However, on the other side, the Democratic Party is concerned with the fake news, aggression, and hate speech allowed on social media and wants more regulation to come from Section 230. The Biden administration has announced in 2021 that they have many new concerns about the power of social media platforms and ways to hold them accountable. President Biden has come forward stating that he wants Section 230 to be revoked, as he believes that tech companies should be liable for certain types of content posted on their pages, especially when it comes to real-world effects like the invasion of the White House. More recent news around Section 230 is individual states trying to create their own regulatory laws to take on Section 230 into their own hands. For example, Texas tried to enact a law regulating how the companies can moderate the content of their services, attempting to limit the ability of web services to ban users or to remove content that they think violates standards, saying companies apply their rules unfairly. But as of June 1st, the Supreme Court decided to block the Texas law from being able to be enacted. There have also been 3 new bills extended off of Section 230 recently, 1 in California and 2 in the US Senate, taking aim at online social media platforms. 2 in the Senate are about altering existing duties to prevent or migrate certain harms to users, particularly minors. The bills are all being talked about due to social media companies knowingly targeting minors who are vulnerable to the mental health impacts of social media. Although Section 230 says that companies will not be held liable for content produced, the new bills will be holding companies liable if they are knowingly or negligently causing or contributing to addiction through any act or omission or any combination of acts or omissions. California's new Social Media Platform Duty to Children Act is being introduced as a social media platform act if adopted, and it will require that online social media platforms act affirmatively to prevent harm to minor users. Additionally, the Senate is trying to pass the Online Kids Safety Act, which would require online social media platforms, regardless of size, to provide certain settings to help facilitate parents' efforts to protect their children from harmful content and potential addiction. With the intense controversy around Section 230, it will stay in the media, and we will be dealing with many adjustments for the decades to come.
Big win for the tech world today and for social media especially, as the Supreme Court blocks the Texas law from going into effect. Julia Borston is here with the fallout. Julia?
Well, Kelly, I would say it's a temporary victory for social media platforms. The Supreme Court temporarily blocked a controversial and sweeping Texas law that would prohibit online platforms such as Facebook, Twitter, and YouTube from moderating or removing content based on the viewpoint of that content. We've gotten no comment from the tech companies themselves, but the industry groups that they're working with are working to block the law. They argued that, quote, HB 20 would compel platforms to disseminate all sorts of objectionable viewpoints, such as Russia's propaganda, claiming that its invasion of Ukraine is justified, ISIS propaganda, claiming that extremism is warranted, neo-Nazi or KKK screeds denying or supporting the Holocaust, and encouraging children to engage in risky or unhealthy behavior like eating disorders.
It's a big win for the tech world.
Okay, so Section 230 has had a huge impact on our country, and even after 25 years of it being in place, there is a lot of controversy in ways it is developing to better fit our current world. I hope you learned something new about Section 230, and thank you for listening.